Right, very warm welcome everyone to this second session of this launch conference, and I have the pleasure to introduce two of our speakers this morning. One of them is Damian Chalmers, and the other is our very own Marie-Pierre Granger. Damian is a professor of European law at the LSE, and he's also the head of the LSE's European Institute, which is kind of a big brother of our future center here at the CEU. Damian's list of publications is so long that it would take us most of the allotted 50 minutes that we have here, so I'll just simply say that he's the author of one of the really core texts in the field of European law, which is called European Union Law, or European Union Public Law with the Cambridge University Press. Damian has 20 minutes, which apparently is an ambitious time frame for the amount of things he will want to go through, and then Marie will have 5 minutes to comment, and then we'll open the floor for discussion. So without any further ado, Damian, the floor is yours.
Right, well, I feel a bit embarrassed about being here, because in a sense, I think it was quite wise to talk about the Court of Justice in the middle of the morning, when everyone's woken up, and not just after lunch, when it's always a difficult challenge, because in some ways, well, probably always, it's arguably the most arcane of topics. It's seen as the most impenetrable of the institutions. And yet, it's also seen as an institution that unites governments in their hostility towards it. That it's not just the British who tried to dismantle it prior to Amsterdam who dislike it. Giscard d'Estaing, the father of the convention, was the first to say that it was an illegal court. It shouldn't really exist, but that was back in the 1970s. And all manners of German politicians, from Helmut Kohl to the, well, I don't know if he's a politician, but to the president of the German Federal Court, always bemoaning how awful the Court of Justice is. But like economic governance, it was one of the things that was barely discussed at the Constitutional Convention. And I think part of the challenges of talking about the court, if you're looking at it in, say, a public policy context, is there's two ways of looking at the Court of Justice. And here I do what all good academics do, which is simplify and exaggerate and distort. But there is two ideal types. One sees the Court of Justice in the following way, and it's more common, this vision amongst lawyers, as norm-driven, value-laden. Its main job is interpretive. It really sits at the apex of some sort of European civil society, so the cases that come before us are sporadic and disorganized. You get these sort of iconic cases involving poor Belgian air hostesses or dietitians that were wrongly dismissed when they were a certain age from Southampton. And there's all a personal narrative, in much the same way that you find similar personal narratives that emerge when one sees some of the literature on the US Supreme Court. And that's one narrative. The other narrative, which is more common to some visions of political science, judicial politics, sees courts as really just another arena for contestation, where different varieties of actors, sometimes judges, sometimes litigants, sometimes supranational judges, sometimes now national governments, seek to use the judiciary to secure their preferences. It's just one avenue amongst many. And the criticism of the courts, such as they are, depend on which of these two tribes you belong to. One will argue that the court is going wild, is giving all kinds of bizarre interpretations. The other says basically the wrong people are exercising their preferences. Either it be nasty national courts who are just trying to secure things that they can't get domestically through European law, or some sort of litigants that just dislike majoritarian politics. But those are the two criticisms. And it matters a bit which you belong to, because if you're going to decide what the cure to the Court of Justice is, if you think there's a problem, you've got to decide which tribe you think's right, because the cures are different. Now, I think there's some truth in both those visions, but like ideal types, they distort quite badly. And the problem that both of them have is they can't explain why we would have courts at all, and the Court of Justice in particular. If you see courts as just about interpretation and being driven by interpreting the text in some sort of norm-driven way, I can't see why you need human beings. It should just be done by a computer. If law is self-declaring, if lawyers are really this right, then we've done ourselves out of a job. And there is a whole literature on law and community science that says that, with the argument being that the only lawyers left should be those who have created this literature, who set the computer programs. If, on the other hand, you see courts as just like any other bureaucratic actor, as a place for political contestation, preference maximization, nested games, etc., then there's a question why governments would want courts at all. They're dispersed, they're difficult to control, they have personal placement is impossible, they're reactive, you can't put firewalls in. On any kind of principal agent model, you should use something else rather than a court. And governments frequently do. They're called regulatory agencies. And so there's a problem. Why do we have these things? And why do they persist so much? And what I want to argue now, well, now in the next 15 minutes, and this is really what my little talk is about, is that both of these literatures are interesting, but they pay insufficient attention to the structures of the law and how these, if you like, frame the game. That on the one hand, courts are there for litigation, for contestation, for management, to argue that actors don't try to manipulate the processes, as some formalist lawyers do, is just crazy. On the other, these very rules of the game structure how actors can, who plays in the game, and what the game is, basically. And that's what I want to talk to you a little bit about. And I want to talk in particular about the preliminary reference procedure. This is a procedure by which national courts refer matters of EU law to the Court of Justice. And it accounts for about 45% of the court's judgments every year, but these are the controversial ones. So what goes on there? Okay. Now, judicial politics. As I'm not talking to many lawyers, let's just start off with judicial politics. Judicial politics is the idea that actors use the judiciary to get things they wouldn't otherwise get through other parts of government. Now, if they do that, the first thing you would need is a stable, insulated field of litigation. You need something where actors could get their rents in a clear, tangible way. You wouldn't get new people coming in who could take away the gains you'd got from a court judgment. So you'd need a relatively stable field where everyone knew what they could win. It's predictable who else is on the other, who are the opponents. There's 11 versus 11, or maybe more if you're playing Barcelona, etc., etc. Secondly, judges need to be predictable. And the one thing judges are not is predictable. Judges see themselves as judges. They pretend they're just doing that. But if you look a little bit deeper at what judges do in different legal settings, they do different things. Commercial law, contract law, they mediate between parties. When it comes to things like tax law or regulatory law, they largely get concerned with public order and securing state capacity. Things like due process clauses, trade rights, all kinds of interest in protecting property rights. And finally, they have what they call authoritative settlement. This is actually comes from some right-wing lawyers. It's the idea that judges should tell the rest of the world how to behave and act as the moral conscience for the rest of us. And if they switch between these things, they behave in an unpredictable way. You want them to behave in predictable ways. And thirdly, if you are playing the game, not only do you need these two things, but the entitlements that you are given, the way judges behave, and the opportunity structures should all reinforce each other. And if they don't, you won't get what you want. Okay? Now, that sounds awfully confusing, but let me just say a little bit about judges, and then I'll go to the Court of Justice's statistics. A few things to think about and a few polls when you're looking at it. With the exception of a few Italian and Spanish magistrates who don't matter for these purposes, judges are not formally policy entrepreneurs. They can only decide the cases that come before them. They can't just do what they want. And this immediately creates two things that you have to think about when you're thinking about the world of the Court of Justice. On the one hand, if you let anyone go before a court, it's incredibly unstable. If you think of an infinite world of entitlements where anyone could go before court, it's sort of like the Israeli Supreme Court, they just decide everything, and what happens, they let everyone come and they say, we decide nothing. So you can do that by giving everyone lots of entitlements. Alternatively, you develop strategies to stop that. So you only say the rich or the propertied. This was the traditional way in the UK up until about the beginning of the 20th century, can litigate. The difficulty with that is you then get capture. That if you say, for example, this is the ECJ, that we will set up a system where equal pay for work of equal value, the only people that will litigate are those groups that want to press for more equal pay. So you have to make a decision between, if you like, capture by particular groups or instability. Any policy fit. Second thing about law, this is a very thin view of law, it stabilizes expectations. It makes things predictable. Now, it does this in two ways. Firstly, across space, that it applies across the territory. So any judgment just doesn't apply to the parties, but to everyone. And the problem with that is that most people are not represented, so they get very upset about the judgments and want to change it. This is why litigation always breeds more litigation. The other thing is it does it across time. Judges aren't meant to change their mind very often, which creates a stickiness. That once someone's got their judgment, that will stay there for a while. So these two things create tensions. And what you find is that legislators try and manage this in two ways. The first way is they provide very detailed legislation with very limited entitlements for people to use it. So the legislation contains lots and lots of things that very few people can sue. And the idea is that way you control the setting. The only problem is if your preferences change, you're stuffed. The other is you're not sure really what your preferences are, so you keep it very open. This is what happens in, say, freedom of goods provisions. But then, of course, other people can come along and use it, and it can be quite unpredictable. So you have to make a decision when you're deciding the rules of the game. And these are, once again, ideal terms between detailed legislation, narrow to a few people that can use it, and more general, which allows you to change your mind a bit, but that might get hijacked by someone else. Thirdly, lawyers like to be contrary. They think they know what is right. This is why lawyers don't get political science. There's this idea. But the problem with that is, looked at from the rest of the world, lawyers can hijack the process. They are, if you want, a political community like any other, with their own values, their own capacity for advancing their own interests. And the more uncertainty you have, the more opportunity for them is to do that. They will come along and say, we need a big legal judgment because no one can agree. So look in the US at issues like abortion. Whatever the rights and wrongs, the Supreme Court saw an opportunity there to develop very detailed case law. And the final thing, and this is what something political scientists don't get at all, I haven't seen it in one article yet written by a political scientist about courts, is courts are set up precisely to ignore politicians. They are there as counter-majoritarian institutions. The justification is the least dangerous branch. It is the only justification for constitutional review. That occasionally they should not decide it according to popular preferences. And that means that they are, as judges, there are particularly strong pressures when you get issues of things like post-material values, individual autonomy, minority rights, any groups that could not be represented through majoritarian institutions to do the opposite. This is seen as the good judicial thing to do. So the Court of Justice comes under a lot of pressure from national constitutional courts precisely when the issue is at its most populist. So that's that. Now, 8 minutes to get back to Europe. If you look at these things, courts and all these four things have to take a vision, and legislatures do, as to how the game works. Okay? Now, going to the EU. First of all, can the EU work as a system for judicial politics? Would it make sense if we think about it, given that we think the court's so important? Right, this is the number of regulations and directives and judgments according to the Commission and the Court at the end of 2009. It's a huge amount. And if the Court was deciding all about that, it would be a very, very powerful institution. Everyone would be litigating all the time. Things would be very unstable. Okay? But if you thought that the Court was potentially regulating on 8,000 instruments, that's 70,000 pages of legislation. It's impossible. Now, you can't read this because I can't get it any smaller, so I'll translate it for you. What is interesting, however, about the Court is it's irrelevant for most of the EU. That there are only 6 or 7 fields where it's important. This top one is taxation, which is incidentally the same as this one, which is tariffs. So tax is a big thing for the Court. Approximation of laws. I'll just go back to the previous slide. And what you find is 6 or 7 of fields account for almost all Well, about 60% of the cases. Approximation of laws, tax, economic freedom, environment, area of freedom, security and justice, agriculture and social policy. And what is interesting is that has not changed, with the exception of the area of freedom, security and justice, in the last 15 years. Despite large amounts of legislation coming out, new actors, new member states, you'd expect it to change. It doesn't. Suggests, despite this huge amount of legislation, there are stable fields with stable rules of the game going on. Otherwise, you'd expect more variation over time and more law to be being litigated. So what I went and did and had a look was, I went and said, well, what's going on there? Who is actually litigating? And what we find is, well, in some senses not very interesting, in other senses very interesting. Very briefly, about 50% of the court's disputes are public, 50% private, about 60% involve just domestic actors, no transnational actor, 40% involve someone from another member state. There's complete legislative dispersal between the instruments now. You find no economic or social actor dominates the use of EU law. I talk about a sword, that is when an EU law is used as an entitlement. Someone is using it aggressively to claim something new. So what you find is on its face it looks very ordinary. It's completely dispersed. And the only way you can then reconcile these things with the earlier thing, which shows that everyone's litigating in the same area, because this suggests a civil society. It should be just litigating everywhere, is to suggest that maybe there are multiple fields of judicial politics which are each relatively self-contained. These are all my slides, which just show you that it's dispersed. And what I will tell you in the next 5 minutes is basically this is what I think the Court of Justice does and why people find it problematic. And there are 4 things it does, 4 rules of the game. The first big area where it adjudicates is what's called approximation of laws. This is a huge amount of EU legislation that governs things like the single market. If you look at who sues here, multinational enterprises account for 38%. It's really high. Bear in mind, 50% means you're in every case, because there's 2 people in every case. In these fields, you find very few salient judgments. These judgments are not controversial. So what's going on here? What's going on here is going back to this. Now, what happens with single market legislation is it's very detailed. States, it's used to secure multinational preferences. The states don't give many people the right to sue other than multinationals, and it's just arbitrating over small things, finessing the details. That is what most of the case law is about. And I'll just go back here. That's the breakdown. But you'd expect it to be a lot more. The fact is, if that's what it's about, then you shouldn't be using courts. Multinational enterprises, if you're talking about effective transnational rules, you use mediation, you use arbitration. This is used very, very rarely, given that we have 1,400 directives, precisely because it's an inefficient system of dispute settlement. Now, the second area where there's really high litigation is in the areas of tax and environment. Now, what you find here is the person that's being sued, this person is a dominant litigator, in many cases, is the state. And you say, well, that makes sense because the state taxes people, so they should be involved. But what's interesting about the cases is that in most of the cases, it's the state doing the suing. And this is because EU law gives states new capacities to tax in indirect taxation. VAT, which we all hate, is because of the EU. Environmental regulatory capacity is because of the EU. It gives regulatory agencies lots of powers. And the state, when it wants to increase its power, makes a dubious claim that it can tax something under EU law, typically against a multinational, so the multinational will resist, and it then brings the case. Okay? And so you find that the state is a dominant litigator, often against large companies, but also against small companies. And these cases are not controversial with the states, unsurprisingly. The Court of Justice is here acting as their handmaiden. as their agent. So very briefly, these are pretty pictures. You find the same for tax, by the way, as for environment. The third story is property rights. And this is where you start to get controversial cases. And this is in agriculture, free movement of goods. To some extent, in some of the taxation, this is free movement of services. Now, the people that use these are all the cases you learn about when you do EU law, and you'll hear that Cassis de Dijon has changed the world for the multinational. The only problem is that most people who sue under these things are firms of less than 1,000 employees who don't export anywhere other than next door, i.e. the next door village. And if you look at all the cases, you have to be really annoyed as a firm to take the thing all the way to Luxembourg. You've got a 50% chance of winning, if you're lucky, because states' lawyers are all going to be mobilized against you, not just your states, but every other states. And it's going to cost you probably about 60 to 70,000 euros. So you do your cost-benefit analysis, they've really got to be annoying you before you're going to take it to Luxembourg. So what happens is, the cases that get brought are not because they actually affect transnational trade, but they're about property rights. They affect a state's business, and it's unhappy at the level of lost business opportunities, typically in its domestic market. Now, because you've got a very fragmented litigant base with people arguing about everything, this is where you tend to get strong lines of case law, trying to bring it together. Lawyers come in, ambulance chasing lawyers. The justification, we have to bring a single narrative, and you get some hijacking by specialized European legal communities who tell the member states they're wrong, crudely. But these are highly controversial. And 2 minutes, yes. I've only got 2 more slides. 4th slide. The last one is court as the moral conscience of the EU, authoritative settlements. Now, these areas, this is where you find individuals and associations, litigants. And you never know whether it's an individual or an interest group that's behind it. It's impossible to find out unless you talk to them, and in some cases they'll still not tell you the truth. But immigration and asylum, which is area of freedom, security and justice, social policies, equal opportunities, but also environment, you find very high individual litigation by non-commercial actors. These are the decisions that get the member states most upset. Equal opportunities, age discrimination, gender, EU decisions on asylum, counter-terrorism, protecting fundamental rights against terrorism if you're the court. These are all the things that have got member states frothing at the mouth. And it's where there are incentives, strong incentives from both litigators and from constitutional courts for the Court of Justice to be the moral conscience. They're the only cases that come through pushing for this. No one is ever pushing a case to argue that the EU should take more repressive measures in counter-terrorism. And so this is the 4th narrative. And once again, because it's a very fragmented base, you get strong lines of case law and lots of EU legal academics thinking they're the world's conscience. So these are the slides. And this is my final slide, and then I'll stop. Now, what I've tried to do is to say that if you look at the legal design, you find entitlements and the rules of game shaped for these 4 venues in a way that they're all reasonably stable and privilege different actors. And it's the actors who litigate that decide what we think of the court, because they think what it can decide. And you've got to come, do you think, well, is this a good thing? I don't think the court should be a commercial mediator. It's not efficient. I don't think it's the job of courts to secure extra powers for the state. I think that's democratic politics. There are roles, if you look at the literature, for courts as protectors of property rights and as the moral conscience in cases of actors who cannot be represented effectively through representative institutions. But it's always very controversial, and you have to have a high trust in the court for this to work well. And when you look at other courts, like the US Supreme Court, the German Federal Court, this has worked, but it has not been easy for those courts. The issue for the court is the one area where it could act like a court is the areas where there's most controversy about its role as an institution, and actually where there's least trust. And that is a bit of a challenge for its future. And I'll stop there.